Hi, good afternoon, and welcome to episode number 30 of At Your Service with Haber and Martinez. Today we are joined by a special guest. You can see her prettying up our screen in the top left corner, at least that's how she appears to me. Sheila Zolnoor, who is a local attorney. I'm going to talk a little bit more about her in just a moment. Our episode today is entitled DV on VD, that is domestic violence on Valentine's Day. And happy Valentine's Day to everybody. Sheila, happy Valentine's Day to you. You look lovely in red.
Thank you.
Edward, my friend, good to see you. I know that there's red on your shirt. Perhaps you can stand up so the audience can see. There we go.
And I always use the fallback. My underwear is red because you know.
Yes, we understand. You can keep that to yourself. Let's talk a little bit about what our show is going to be about today. And first, let's talk about our guest. Sheila is a local attorney. Her offices are in Broward, although she doesn't limit herself to just Broward. Her address and contact information are scrolling on the bottom of the screen. Sheila graduated from the University of Florida Law School in 2007 and spent the first 5 years of her career as an assistant public defender up in Broward County. Subsequent to leaving the PD's office, she dabbled a little bit in family and maintained her criminal practice and has since settled in her niche job, which is primarily criminal defense with a focus on domestic violence cases, both civil and criminal. Although certainly she's competent to handle damn near anything that comes across her desk. Sheila and I met on opposite sides of a civil domestic violence case, which we were able to resolve amicably. And since then, she has been a veritable fountain of information for me, kind enough to field my calls and be patient with me in terms of helping me with my more difficult domestic violence matters. So apart from the privilege of having her as a virtual digital Valentine's Day date, albeit, with Martinez, but still better that than nothing. I thought, what better day for us to talk domestic violence and dovetail into a Valentine's Day discussion as well, because unfortunately, as we know, happy people turn into angry people at the snap of a finger. So, if you don't show up at home today with the appropriate Valentine's Day gift, or you put the wrong woman or man's name on the card, you're going to be in some trouble. With that said, thank you again for coming, Sheila. We're so glad to have you.
My pleasure. Thanks for having me.
So let's talk a little bit about domestic violence. Let's tell the audience, if you would, the difference between civil and criminal. I mean, not all the differences, but just generically, what are the different models that we have in terms of domestic violence?
All right. So with a criminal case, first of all, it's the state of Florida bringing the charges, right? It's not one party against the other necessarily. It's the state of Florida bringing the charges. And obviously, in a criminal matter, it's a beyond a reasonable doubt standard. And with a restraining order, a civil restraining order, it's the preponderance of the evidence, which just means that the judge has to find that the evidence is more likely than not that you've been a victim of domestic violence or you're about to be the victim of domestic violence. So in a criminal case, the crime of the battery or the assault or whatever it is would have had to have already happened. And with a restraining order, with a civil restraining order, you can seek one before any violence has actually occurred. You can seek one when you feel that there is a danger of violence happening to you, and the judge would just have to find that you are in imminent danger in order to grant it ex parte.
So the standards are different, the judges are different, the forums are different, the rules are different. They're completely different proceedings. Let me ask you a question, because you brought up an interesting point that we know the answer to, but the audience may not. So in a criminal case, the state of Florida brings charges. So let's say Ed and I are involved in an intimate relationship, and Ed is abusive to me.
You got the better of that. You got the better of that relationship. That's all I'm saying.
And I go ahead and call the police. The police show up and they arrest Ed. Now I decide I don't want to prosecute Ed. It's not my case, right? It's the state's case. So what happens there?
They can continue. And I've seen them continue before. So if they have a 911 call, for example, they don't necessarily need you to go forward with their prosecution. I've seen them bring in victims against their will before. They'll have their detectives go out and pick them up to come and testify.
Now, that doesn't happen in routine misdemeanor cases, does it? I mean,
Not
Broward, anything goes, but here in
No,
Dade, there's a
I'll tell you,
0%
the only time
chance.
What's that?
Here in Dade, there's virtually a 0% chance of that, at least in a misdemeanor case.
Dade
No,
and
I don't know, Mike. I had one where they were pushing and pushing and pushed it all the way to the day of trial. And the victim had to come in because they were terrified to just ignore the state.
Okay, but I'm saying if a victim decides they're not coming and they don't cooperate in a misdemeanor case, you're going to tell me that here in Dade County, the state attorney's office is going to send the sheriff out to go get them?
They didn't.
They can. It's not that they can't. Have you ever seen that happen? Ever?
Yeah, no, not on a misdemeanor. You're right.
Right,
They didn't-
exactly.
but
right?
they
Like
push.
it's gonna if
They
the victim
push
doesn't.
like hell.
What's
Go
that?
ahead, Sheila.
But they push like hell.
Right, but in Broward they do. In Dade, I feel like if the victim's like, I don't want to engage, then they're like, okay, well, one less case. But in Broward, sometimes they'll continue going, and but the case that I'm thinking of where they actually went and they picked up the victim was a felony DV case, and there was a very serious injury. It was a stabbing, and
Right.
she didn't want to go forward, and so they were like, you're going forward, and they went and picked her up. So
I think that's an interesting distinction, because let's just start with the premise of the sliding scale of DV cases, and I have two observations which you can pick apart as you wish. The first would be that one of the reasons that the system treats DV cases so differently than other cases is because the nature of every DV case is some sort of interconnection, be it emotional, financial, familial, whatever, between the parties that takes it apart from some random act of violence or criminal case that occurs between strangers. So
Right.
therefore, the possibility for escalation, future violence, additional violence is significantly higher between those people. And then
Yeah.
the second component that I would say, and again, feel free to hit on either, is that, as you said, as we alluded to, there's a sliding scale, right? We could have a misdemeanor assault. Oh, I thought he was going to hit me. We could have a misdemeanor battery. He smacked me. We could have a felony battery. He smacked me and I got injured. We could have an aggravated battery. He used a weapon. We could have an attempted murder. We could have any of a, sliding scale of more serious criminal offenses. So with that, go ahead.
I don't really know what I want to hit on with that, but yeah, there is a sliding scale, and I think that that's why it has to really be evaluated on a case-by-case basis, because a lot of times you do have victims who maybe the state, after investigating, realizes the victim maybe was just kind of using the law as a power play. Maybe.
So we're going to get to that one too, because
Right?
I call that strategic weaponization.
And before we go too far, as a former state attorney, I want to just throw something out there. I also understand if the reason that the state attorneys push the cases is a couple of reasons that I understand completely. For example, the battered spouse syndrome, where they're fearful. They want to make sure that it's not that the victim is still terrified of the defendant, and they got to talk to the person. They want to sometimes see them in person, face to face. I get that. I also understand that, God forbid, the victim says, no, hell no, I don't want to testify. And then 3 weeks later, the defendant kills them, that the family is going to say, oh, the state should have asked more questions. They should have looked into it.
So that's why the
get
state
that.
attorney's job in DV is so difficult, because it's really hard to figure out, right? If the
And I get that.
forthcoming, it's really hard to figure out, is this the battered spouse syndrome? Is this person going to now protect her abuser because security, he's the father of her child or whatever? It's hard to sparse it out. So
And I get that.
I
I
don't
don't get that. But I just don't like when they threaten to have them arrested, especially when they've spoken to the victim, because a lot of times they do actually speak to the victim, and they get an affidavit of non-prosecution. Or Michael, I think you've done it, where I've represented victims and called the state and said, listen, they hired me specifically to tell you to go fuck off, and they still keep pushing the issue. It's a fine line. I get it, but sometimes you got to say, okay, enough. This one doesn't want to cooperate.
So just so to give the audience a little bit of perspective, it's very common. I would say more often than not that most misdemeanor cases, most DV cases, at least of the misdemeanor variety, first-time offenses, in hindsight to the parties, they just want to be done with it, and they don't want the system involved. They don't want the cops involved, the courts involved, the prosecutors involved. They just want to get back to par. So in other words, the victim feels like, look, the defendant learned his or her lesson. We're moving on with our lives. But as Sheila said earlier, in the criminal context, you don't get to control that per se. Now, there are ways that a skilled and experienced criminal defense attorney can assist. And so what Ed was alluding to is, and this has been my practice for many years, when I get a call on a DV case where the victim and the defendant are on the same page, I know that I cannot represent, I mean, theoretically, there are ways that I can represent both, but I never do it because it's just ripe for problems. So I bring in another attorney, whether it's Sheila, whether it's Ed, whether it's whomever, and that attorney's job is to represent the other party, truly independently, paid independently, advice is independent. While we are on the same page in terms of we all want the same thing, when I bring in that other attorney, their job is to say to the person, look, I know this is why I was brought in, but I need to explain to you and make sure you understand what your rights are, what the possibilities are, and what it is. And then when you make up your mind and tell me what you want me to do, I'm prepared to do it, which may result in a no prosecution affidavit or something else.
But I mean, remember, the state attorney's office also has their victim advocates who also explain to the victim what their rights are and, you know, it's, I don't know. Sometimes I get the feeling that they kind of push them in one direction versus the other.
Kinda?
No,
I'm just cognizant of who might be listening. So yeah, yes, of course.
No, they do push them.
I'll say it because I don't give a shit who's listening. Some do. Some prosecutors are amazing and super ethical and a joy and a pleasure to say, I'm so proud that that's a state attorney. And some are not. Some are either stupid or unethical or lazy. I don't know what the fucking problem is.
You know,
but some are not. We're all human. And I don't blame any state attorney. I don't blame Kathy. I don't blame that. They're so far removed from some of these line ASAs that they don't understand until it gets on their radar. And I can tell you here in Dade County, Kathy Fernandez-Rondel has done a good job when it gets on her radar. I know that. And I also, like I said earlier, I get it. You do have to push a little bit. When at least when my clients hire me, I tell them, listen, be ready. State attorney is not just going to roll over because your wife or your girlfriend or your husband or boyfriend, whatever, says, I don't want to prosecute anymore. They're going to make sure that you take it back. They're going to push because they need to make 100% sure that you're not, just terrified of this guy and there could be other issues. So I get all that.
Yep. I mean, because just imagine, I could not imagine being in the position where I was the one responsible for someone getting out or the charges being dropped and then the person ends up dead 2 weeks later. You know what I mean? That's a very scary prospect. I don't know that I would want to be responsible for that.
Well, that's the nature of our job, though. I mean, as criminal defense attorneys, we're not guarantors of future conduct. We're there to ensure due process and to serve our clients as they have hired us to do.
That's why I prefer to be on this side of it. But I get why they're so apprehensive sometimes, I suppose. But
well, and that dovetails into judges too, right? So I don't know how they do things up in Broward, but I can tell you, so that the folks understand, anybody who gets arrested in the state of Florida for any domestic charge, and all that means is that the police take their little stamp that says domestic violence and put it on the A form, and bam, it's a domestic case. When that happens, two things occur. Number one, you cannot be bonded out unless you physically appear for a bond hearing. You must go to your bond hearing. In virtually any other charge, apart from PBLs and non-bondable offenses, you can post bond before that bond hearing and you're released. But DVs require a mandatory court appearance. And the reason that they require a mandatory court appearance is because every DV case comes with a mandatory stay-away order. That means the judges have absolutely zero discretion in the state of Florida. They must order the defendant, the accused, to stay away from the alleged victim or victims as a condition of bond. So if they violate that condition, their bond can be revoked and they can be, thrown back in the pokey. So we start with that premise that that's where you begin on the backside of that machine that's going to kind of steamroll you.
Right. And so just so the audience knows, I don't know if everybody knows, PBL means punishable by life. So that everybody
But how
understands.
many times have we all seen the victim come in either at the bond hearing or at the arraignment, at the first calendar call, and she's saying or he's saying, I want to have contact. And at that point, I'm just like, why are you guys even pursuing prosecution? This person's coming in here saying, I'm not in fear. It didn't happen. They're recanting, asking for the person.
So as a pro tip here, I never allow my clients to do that. Number one, I don't want to put them in a position where they're potentially accused of perjuring themselves or providing false information to law enforcement.
Wait, what do you mean your clients? Your clients?
Well, if I'm representing the victim,
Okay.
I would never do that. But I before I even get to that, I want to touch on more on what you were just saying, because that's really important. So what I was going to say is, we were talking about prosecutors engaging in self-protection. The court does the same thing. So that stay away order, there is no rule or requirement that says that stay away order cannot be lifted or modified. It can be. But there is an unwritten rule that no judge ever in the history of domestic violence cases has ever rescinded a no contact order. They may modify it to no violent contact, but they won't remove it entirely because they have to protect themselves, right? So that way, at least they can say, well, look, the victim came in, the victim was placed under oath. We asked 6 ways from Sunday. They were adamant that they wanted to have contact, but I wasn't going to allow contact without some protection by the court. And that's why we modified. But the point I was going to get at is, here in Dade, there's an unwritten rule. It's a conspiracy amongst many of the judges that they will not even consider amending to a no violent contact until 30 days have lapsed. Can you imagine forcing 2 adults in particular who know what they're doing, who, look, maybe had a bad night, one of them said or did something stupid, maybe neither of them even called 911, maybe it was a neighbor or a busybody who overheard something. They find themselves in this position, and now you got a judge that won't even let you speak to your wife or your husband or your son or your daughter or your boyfriend or your girlfriend. It's insane.
Well, how about the flip side of that, where you have, they ignore it. They ignore the no contact, right? They're like, whatever, who's going to find out? The victim in the case is like, you can come back home. It's fine. I don't care. They come back home. They were invited into the home. And then 2 weeks later, she gets mad again and says, he came to the house. You're still in violation. Even if you got invited, you're still the one that gets in trouble.
Right. I wanted to mention that because I think that's huge. It's one of the things I always tell my clients, even if they don't want to get back together, even when they say, no, fuck that bitch, I want nothing to do with her. I'm like, okay, well, listen, if she calls for a booty call or says, I'm sorry, and wants to come back home, and she says, it's okay with me, you need to understand something. This is the way I explain it. Anyway.
It's a trap.
I say, I said, the judge is like your parents. Okay. Especially with the ones who had siblings. So you had siblings? Yeah. Okay. All right. So imagine your mom and dad, you guys are fighting, and your mom and dad says, both of you go to your room. And I know Michael started it. Michael, I don't get to your room. And Ed, you get to your room too. And I don't want either of you talking to each other. And I take it upon myself to go tell Mike it's okay. Or Mike comes to me and says, hey, I'm sorry. And then when mom and dad breaks in and sees that we're in the same room talking, guess what? What would your parents do? Say, I don't give a shit. I told you not to talk to each other. I don't give a shit if Michael went to see you. You needed to kick him out of the room. I said, well, the judge is like your parents. The judge is the one who told you not to talk to her. So it doesn't matter what she said. I don't care what she says. You can't be there because you will violate.
Yeah. What you can do, and what I do recommend people do, is when you get that text or that email, preserve it. Because at the end of the day, if things go south, and you hope they don't, but if they do, and like you said, 2 weeks later, they change their mind and now they're upset again. If that happens, and you can prove that that person was reaching out to you, that person was contacting you, that person was trying to get you to come see them, but well, that really mitigates, and it's good fodder for cross-examination because it mitigates against their fear, especially in a civil case.
But Mike, also though, I wouldn't say just preserve it. I would say the minute you get that text, you do, in a civil case, you do a motion to dissolve, right? Because now you have the text. Why wait until a situation where you're being accused of violating to then try to mitigate? I would always say, if you get a text message, immediately file your motion to dissolve the restraining.
See, That's why we have you on here, because you know the civil end so much better. And I'm always thinking on the criminal and not so much the
But
civil.
I'll tell you what I do in criminal, Mike. When I get those, I immediately get a copy of it and I send it to the prosecutor, and I just keep sending it to him. And I just tell my client, listen, every time she says, "Hey, come see me, I love you," whatever she says, let her know that you must in your text messages say you can't contact me. The judge says we can have no contact.
Okay, see, and I disagree with that respectfully, because I think saying that is violating the no contact order. You're not to reply. You are not to reply. If you are under bond, if you have a condition of bond that says no contact, you don't reply. And by the way, same holds true for a civil injunction. You don't reply. Let your lawyer do the talking.
Yeah, but I
always follow the golden rule. Let your lawyer do the talking.
True. And one of my concerns always with clients is that I always tell them, if you're going to say anything other than I cannot have communication with you, or don't contact me, then don't say shit. Don't say I love you, but, or I want to see you too, but don't say shit. If you can't keep your mouth shut, just don't respond. But
right. I always say, I love you too, but you have to go to the state attorney's office and get this case dropped, or you have, because then now you're tampering.
Yes, exactly. This is exactly my point.
The judge doesn't want me to contact you. No, I tell him, if you can't say anything other than when I cannot communicate with you.
You've just communicated. If you say that, you've just violated your own restraining order. You can justify it however you want, but it's violation.
I've never had
whoever's watching, go directly to your lawyer with that text message.
Exactly. I agree.
I concur. Both. I've never had a judge or a prosecutor have a problem with it. Never. On the contrary, the judges have come in and said to prosecutors, he's doing nothing wrong. He's literally telling his fucking wife to stop it because he's not allowed.
No, you're right. In a real world, like practical perspective, before there is some kind of like additional violence, the prosecutors frequently know that there's contact going on between the parties, but they're not going to prosecute them for it. They're not going to do any kind of motion, because they know that they're adults. Like you were saying, Mike, they're adults. They're going to be talking to each other. Essentially, we kind of read into no contact as no violent contact. You know what I mean? No harmful contact. So they don't really pursue it. Typically, I have never seen them pursue it unless there is violent contact.
And I'm telling you,
but the problem is, again, going back to the premise of why DV is treated differently. In these situations, it's very difficult to predict what tomorrow will hold or what next minute will hold. So, let's say that the domestic violence, I had one not too long ago, which I'm sure you both have had, because I'm sure it's a very common basis, where the victim was looking through the defendant's cell phone and came across some racy conversations between another person of the opposite sex, and that turned into an argument. And of course, they patched things all together after all was said and done, until the next time that there was a racy message found, and then it was worse. So, I just think that these things tend to spiral out of control depending upon the facts and circumstances. But I printed out 3 A forms to read at some point, hoping that Sheila, you will put on your PD hat, your former PD hat, and Ed, you would put on your former prosecutor's hat, and we can litigate these 3 actual A forms.
I just want to say something for everybody listening. You're always using me as the ex-prosecutor.
You are an ex-prosecutor.
Yeah, I know, but if anybody's listening, you got to understand that I do my job very well as a defense attorney. Just because I was a former prosecutor, when we come on this show, I end up trying to be the fucking dickhead.
So let me be clear to the audience, Ed. The reason that I use you as the former prosecutor is because you were a former prosecutor, and I think that the fact you were a former prosecutor makes you a better defense attorney.
It does.
Is that okay? Are you happy?
Absolutely. A lot of times,
are your red panties in a bunch still?
No, they can't be in a bunch because they're so small. It's a G-string. But however,
I just threw up a little in my own mouth. Thank you.
And I will say this: sometimes being a former prosecutor gives me insight into what the prosecutors are really. In other words, when you call people, you're trying to negotiate a deal or something, and let's say in a civil lawsuit or something, and I will call the opposing counsel and say, dude, tell me what you need from me to get this resolved. What do you need me to do so you can go to your client and tell him, hey, let's get this done? And sometimes I know that that's what's going through the prosecutor's head, and I'll call him and say, listen, man, I get what you're going through. What do you need from me so you can take it to your chief and be like, now what do I do?
So I have a case in Dade right now. It's not even DV, but it's coming up. It's like a similar situation where there is a no contact order. It's a ex-girlfriend of this guy, my client, who is mad that he's already moved on. Does not have his papers. So she, of course, calls the police and says he came to my house and burglarized it. There's no evidence of any burglary. There's no evidence of him ever going to her house, nothing. And she will not, she won't budge on it. And to the contrary, he's in a band and she's calling his bandmates and saying, can I hire you guys for a gig? Don't tell my client. So she's trying to set him up for a violation of the no contact order. And I've spoken to the prosecutor and she's like, I know it's bullshit, but she won't budge. What do I do there? The witnesses, like the bandmates, are also undocumented. They don't want to be involved. They don't want to have anything to do with it. You know what I mean? But that's just an example, like weaponizing a no contact order in general. It's not a DV case, but it's still a no contact order outside of a DV situation.
All right, let's go through the A forms, brother. Let's go.
Let me give you an A form. Ed, I have to apologize because I know I actually read this A form to you once. Sheila, this will be a first for you.
I knew you were going to read that one.
This is from 2009. Okay, this is an actual A form from.
Is one of your cases?
Yes, old case, obviously. Names and information will be redacted. On the 9th day of September in 2009, the defendant and the victim are live-in boyfriend and girlfriend. While they were having sexual intercourse, the victim agreed to insert a cucumber inside her vagina. Moments later, the victim removed said item and threw it to the side. Defendant became angry. He retrieved the item from the trash. He repeatedly hit the victim with it on her face until it broke. Defendant then repeatedly punched and kicked victim about her body. Victim sustained multiple bruises to her face and body, photographed and documented, also sustaining 2 fractured ribs. Defendant was arrested. Charge, aggravated battery, great bodily harm.
It is an ag-bat. He used a weapon. Do you know the definition of a weapon? I had to look this up once. Early in my career as a prosecutor in juvenile. A weapon is anything that you use it in a manner other than the way it was intended. And I was doing that specifically in juvie because a couple of kids, they got jumped at one kid, and when the kid was down, they were kicking him with their shoes. And the PD was telling me it's not an ag bat because it was still their foot. So I had to look it up and be like, no, it's an ag bat because a shoe is not meant to kick people in the head. It's meant to be walking. So yeah, what was it? A cucumber? What was it again?
Cucumber.
You hit somebody with a cucumber, brother. It's an ag bat. I'll go first. All right. To me, this is a no-brainer. Even as a defense attorney, if my client was sitting in front of me, I'd be like, dude, you are so fucked. When she says no, it's no. No means no. Okay? Even if she's on the verge of an orgasm and you think you're going to give her the best orgasm she's ever had, if she just hangs in there, she says, stop it. You got to stop it. And then you made it worse by beating the shit out of her. I mean, why would you do that? Why? Unless you can explain to me how she got a couple of cracked ribs. How did she get the cracked ribs from other than whether you explained it?
Ribs and cucumbers.
As a prosecutor, I'm going full bore on this guy. Sorry.
You got any defense to offer, Sheila?
First of all, I was going to send this podcast to my saint of a mother, who I can no longer send.
But this is true. This is not a joke. I mean, this is an actual A form I read.
It's an actual A form.
Yeah, Mom could do a public records request on this one.
My only defense would be something weird. It's going to be, first of all, I need more information, right? Like I need to be able to build this stuff. So I don't know. Is she into kinks? It sounds like she's into kinks. How do I know that she didn't want the beating, right? Like, because things cross lines sometimes.
That was the defense. That was exactly the defense.
Oh.
She enjoyed it. Now, you know what? And can I just say something for the audience, for the non-lawyers? This is exactly what is my biggest pet peeve when I was a prosecutor with defense attorneys. How does the prosecutor know that she's into kink? He doesn't. He's got 300, 400 fucking cases. He can't sit there and investigate everything like it's a fucking movie. He's not fucking.
But
Jack
that's your job as a defense attorney.
Your job as a defense. Your job is to not come and tell me but he's a nice guy. Well, I got an A form that says he broke his girlfriend's ribs for not inserting a cucumber in her vagina. Doesn't sound like a nice guy to me.
No,
You
that's
have to bring it to me.
My job's not to tell the prosecutor that my client's a nice guy. It's to paint the picture of what actually happened. You know what I mean?
But you know how many do? Sheila, you know how many do? Do you know how many lawyers come to me and be like, Ed, he's got a family. He's a nice guy. They got kids. Well, the kids were not in the room because I'm sure if the kids find out that daddy broke mommy's ribs because she wouldn't put a cucumber in her vagina, they'd be a little upset at daddy too. So bring me
mommy was into it.
Right. You got to bring me something. And then, Sheila, what I would tell you again, if I'm a state attorney and you say to me, hey, she's in the kink, I would say, okay, well, bring me something. Bring me a video. Show me a video or a picture.
Of course you'd want a video of the kink going on in that bedroom, Ed.
No, but look, even a picture of her at an S&M party dressed like, the I don't even know which is the M, right? The M is the masochist, the one who likes to get her ass beat.
Yes.
Bring me a picture or some evidence that could show me, okay, hard evidence, proof that she might actually be into this, and she just got a little pissed off for something else. Because that's the other thing I would tell you, Sheila. Okay, that may be true, but I'm sure they have a safe word. Is she going to say that she had a safe word, or is this because in the middle of it she saw a text or something about him banging some other chick, and that's
exactly. Sorry, did the A form make reference to like bruising? I don't know how old bruises are. What color of bruises? Or are they days old? Are they a week old? Is it because she got mad because she saw a text message? I don't know. Any more information?
Right.
And again, well, no, but you did hit the defense right spot on. That was the defense in this case, that it was consensual and that she was an S&M type sort and that her injuries pre-existed.
How'd the case work out?
Did it work?
How'd it work out?
Didn't work out very well at all.
Wait, was this too?
Because she didn't go along with it. She didn't go along with the defense.
Okay.
So, yeah, he put that forward. She didn't agree with any of it. And you know what? I don't care how you go. The truth is, beating someone in the face with a cucumber, he might have gotten away with. But punching her and kicking her and breaking her ribs is where the line was drawn.
Spanking her with the cucumber. I mean, you are having sex. You didn't know. You thought it was all part of it. So I spanked her butt with a cucumber. Maybe. But when you hit her in the face, like, come on, man. Nobody wants to.
This was an example. This was an example of overboard. All right, let me give you another one. This one I got to put the light on because the print is a little too small.
That was a little unfair to Sheila because, come on, like seriously, that one.
That's okay. She's a big girl. She's heard worse. She was a PD for 5 years, for Christ's sake.
Please, I'm not the sensitive one. She is.
All right, here we go. Bear with me because I got to read here. Okay, I made contact with the I responded to blank address in reference to a domestic battery. I made contact with the reporting party and the ex-girlfriend victim inside of the listed location. So the guy who ultimately got arrested is the one who called the police, okay? And it was at his house. The victim advised that the offender pulled her arm and slammed her up against a wall. Victim and offender dated on and off for 2 years, resided together for 2 months. Fire rescue responded to the location because the offender complained of neck pain. The offender stated that the victim came to his house to get her items. The offender further stated victim entered his bedroom against his wishes. Offender said that while the victim was inside of the location, she punched him in the mouth with a closed fist and scratched him on the neck several times. Offender noted that the victim was throwing items at him inside of his bedroom. The victim stated that the offender had told her to come to the house to pick up her property. The victim stated that the offender initially did not want to let her into his bedroom, but after she called the police, the offender allowed her to enter his bedroom. So
after she called the police?
She told the police that she called them, but there's no record of that. The victim stated while she was inside the offender's bedroom closet, the offender got mad because she was moving his items around in order to get to her belongings. The victim stated that the offender pushed her down, grabbed her by her right arm. The victim stated the offender dragged her outside of the closet, punched her, pushed her outside using a chokehold. The victim advised that she was unable to breathe while she was being choked. I observed bruises on the victim's right arm, and I observed scratches on the offender's neck. Based on the totality of the statements, I deemed the offender to be the primary aggressor. The offender was arrested for simple battery and transported.
Was there any proof that he had told her to come to the house to get her stuff?
Other than her testimony, no. So it's a he said, she said. She claims that she was invited. He claims that she showed up uninvited. She claims that he assaulted her or battered her first. He claims that she battered him first.
You want me to go first, Sheila? Or you? Oh, sorry, Mike. I thought you were done.
He gets arrested. She does not. She has no visible signs of injury. He does.
Well, she had bruises, according to the cops.
Bullshit.
Can I tell you what, again, as a state attorney, what I personally would have done, and I know there are a few in the office who would have, maybe not in the domestic violence unit, but the rest of us who, have common sense, I would have called the victim and I would have said, I have one very, very, very troubling issue here. If you were afraid of him, why'd you go to his apartment? I know he called. He said, come pick up your shit. But if you were afraid of this guy, why'd you go to his house? And if he was such a dick, why'd he let you into the bedroom? And if he was such a dick, why? Like when she says, well, we broke up and he told me to come make my stuff. I didn't think he was going to hurt me. Okay. And then when you went into, why would he let you in the bedroom? Why wouldn't he have gotten your shit and put it by the door? Did he explain that to you? No. Okay. Why did he let you in the closet? Why would he let you in the closet?
Because that's not what happened. She went on and she's like, I'm here to get shit. She went into his closet. He's like, I said, get the fuck out of my house. Maybe he escorted her to the door. She gets mad. She claws at his neck. She does whatever she does. And then she cries victim to the police.
I think with common sense, and again, I meant that facetiously about the domestic violence unit, just some of them don't have common sense. They don't have life skills. They don't have life experience. Okay. I may or may not have broken up with a couple of women in my lifetime. And when they don't want to leave you and they want to keep coming around, you tell them you got to pick up your shit. And the first mistake I made once was when she said, all right, I'll be over there. Okay, come by. And I let her in. And I had to be the one on 911 calling the cops saying, if you don't come get her, I got a banshee. I got a wild animal on my hands. I got scratch and blood all over me. I've got her pinned on the ground right now. And you could hear her screaming on the 911. And I'm like, I can't let her go because she's got big nails. And by the way, she was a big girl. She was 6 feet tall. I was like, she's a big girl. So you got to come get her. I learned my lesson. After that, I would say, you can come pick up your shit. It's going to be on the porch. But this kid didn't know. And so you've got to see, this is the other thing. State attorneys need to push sometimes, and some of them don't. They're terrified. Just like I want to add, the cop, in my opinion, was terrified. I think respectfully, and I mean this in the nicest possible way, I think he was very chauvinistic. And I think he said, well, I'm not going to arrest a female. I'm just going to arrest a guy.
He was a she. It was a female officer.
Well, there you go.
That just doesn't make any sense. If there's no signs of injury and only one of them has any signs of injury.
Well, let's be fair. The A form says he had.
The A form said that she had bruising, but again, like you said on our first case, how old are the bruises? These are police officers. They're not
up instantaneously.
Exactly. And these are not medical doctors. They're cops. He had fresh blood. He had fresh blood on him.
It could have been a defensive bruise. Look, if you go to punch me, like I want to know where the injury was, because if it's here and somebody goes to punch me and I block it, she's going to get a bruise.
When's got a bruise within minutes?
Bruises don't occur that quickly.
Correct. But he's got scratches. So in my opinion, if I was the cop, if you're looking at the totality of circumstances, and I trained at the academy cops many times, and one of the questions that always comes up is, what is exactly probable cause? And this is the way I would train them. I try to make it as simple as possible. I always used to tell them probable cause is, after you get all the facts, is it more probable than not that the crime occurred? So in this case, if you're looking at the facts, she went to his apartment. Everything was fine. There was no issues until somehow something happened in the closet, and now all of a sudden all hell broke loose. It's a little concerning If he fucking wanted to beat the shit out of her, he would have beat the shit out of her from the minute she walked in. Number 3, he's got blood. She's got a little bruise. If you start looking at it, and I get it, it's tough for the cops because you never know what really happened. But again, as a state attorney in this case, I'm looking at it with fresh eyes thinking, if I were there, I would have arrested her. If I'm arresting anybody, it would have been her. And I think a good state attorney would push this victim and tell her, understand something. My job is to do justice. I got to make sure that you are not lying. I don't know you. People lie all the time, so don't get offended and don't take it personal. But I'm going to ask them, and I used to do this, Mike. I used to tell them to their face.
Suffice it to say, none of that happened with the state attorney in this case. Sheila, go ahead. Run with the ball.
Wait, so what happened with the case?
You want me to tell you, or you want to chime in on your thoughts first?
I've already chimed in. I think
Okay.
it's complete
So I will tell you exactly what happened. Here's what happened. I filed a stand your ground motion in this case, alleging that this
That's what I would have done. Okay.
this maniac alleged victim showed up irate and insane at a place where she was not welcome, and she forced entry. She was abusive, she was physical, and my client called 911. And the 911 call, which you can't tell from the A form, was very clear. My client saying, similar to what Ed was saying, this woman is here, she's out of her mind, she's throwing punches, I locked her in a bathroom, you gotta come get her, because if she gets out, it's gonna get even worse than it already is. This was so clearly a case of piss poor policing that was doubled down on by horrific prosecuting. Because as Ed said, when I filed the stand your ground motion, which laid all this out, instead of the prosecutor calling up this victim and saying, we need to talk about this, they challenged the motion and they forced us to litigate it. And we had to get a ruling from a judge saying that the state is not able to overcome the defense prima facie case here.
Good. I was going to say, so you won. Good.
Yeah.
Of course he won. This honestly is embarrassing to say that I'm a former state attorney. I got to tell you, when I was there, I heard Janet Reno did this. I didn't get this in my orientation under Kathy, but I did get it from one of my very first chiefs, well, my narcotics chief, and also my juvenile chief. Both told me. My juvenile came first. Our job as prosecutors is not to prosecute. That's not a prosecutor's job. Prosecutor's job is to do justice. Justice. And if we can't prove, and I don't know how many times I have to explain this to young ASAs and they think, I'm a defense attorney, I'm bullshitting them. Mike, you knew me as a state attorney. If we cannot prove something in our belief, we don't think we can prove it beyond a reasonable doubt, which means even if I think there's probable cause, if I don't think I can prove it beyond a reasonable doubt, I must dismiss the case.
Never happens, though.
No, they don't dismiss.
Never. I shouldn't say never. But when they know that the case is thin, they say, I have to.
Well, I don't know how things are up in Broward now, but I remember how they were under Michael Satz. And the prosecutorial philosophy under Satz for all of the years that I practiced was let the jury acquit. We are not walking anybody.
Yeah, that's the thing. So I think that there's a lot of really good prosecutors. I, deal with a lot of very good prosecutors, right? They try to do what they can do, but like you said, there was a philosophy at that office at one point that was, we're not just go to a trial. But why would I make my client roll the dice? Because I don't know what's going to happen, right? How many times have you gone to trial on a case that you thought was a winner and you lost? How many times have you gone to trial when you thought it was a loser and you won, right? Like, why would you put someone through that, right?
It's funny. I always say that the only rule in criminal defense litigation is that anything is possible.
Right.
Anything can happen because you just never know. You have witnesses that get on the stand who have given you affidavits and sworn testimony, depositions. They're on video, body cam, and then they get on the witness stand and say something completely different. So
I think a lot of prosecutors do not, the ones that are the bad ones, because there's some very good ones, okay? And even in Broward, I had a case recently where I had to go through 4 fucking prosecutors before I finally got, I'm not going to bore everybody with the details, but trust me.
Thank you.
This was a contracting without a license, and it was not only no evidence of it, there was overwhelming evidence that the fucking victim knew exactly who the contractor was. He wrote him a check. He had sent the text messages. He had sent my client text messages saying, I'm going to send you the stuff so your contractor doesn't come to me. And they were still going forward. But I got one that when I pointed out the evidence, he looked at it. He called me up. He says, put it on calendar. I took it to my boss, his chief, which agreed. He said, we're dismissing the whole thing. So there are some good ones. But I think a lot of them don't understand one basic thing. In my first interview at the state attorney's office, at the end of the interview, they asked me, if we hire you as a state attorney, is there anything that would you be afraid of doing or anything you're afraid of? And my answer to them, the only thing that I could think that I'd be scared of as a state attorney was prosecuting an innocent man. And they both did a double take. And I said, what? Did I say the wrong thing? And they said, no. In all the years we've been doing this, you're the first one who said that. And that's the scary part. Because the only thing that a prosecutor should be terrified of, and I was terrified of prosecuting an innocent man. So if I wasn't 100% sure, and we could never be 100%, but as close to possible as 100%, I would never prosecute, because what if I'm fucking wrong? And I don't think they're, I think it's really incumbent on the office and training to explain that to them. This is not a civil lawsuit. This is not even a civil injunction where maybe you can get a 1 or 2 year stay away order or permanent injunction.
Well, hang on. Let me run with that for a second, because that's another topic I wanted to get onto. When we were talking about differences, and I want to talk a little bit about collateral consequences, because there are significant collateral consequences from both criminal and civil domestic violence cases that are inapplicable in almost any other case. Right. So if I have and temporary injunctions are just that, they're temporary. But if you lose at the hearing for a permanent injunction, and just so the folks understand, a permanent injunction means that the judge has either listened to evidence on both sides and made a decision in favor of the plaintiff, or there was no evidence presented and the respondent failed to appear, and so it was entered by default. But either way, if there's a permanent injunction entered, permanent does not mean necessarily for life. Permanent means for the amount of time that the judge feels, given the facts and circumstances of that case, the injunction is necessary. And so what the word permanent refers to is the fact that due process has been afforded and the respondent has been given an opportunity to know what the allegations were and to respond to those allegations, and then failed to rebut the allegations sufficiently. So permanent might be a 1 year injunction. It might be a 10-year injunction. It might be whatever the judge decides. It might be a lifetime injunction.
It's until further order of the court. So when you want it dissolved, you come back and, you guys readdress the things.
But it's not just that, because you get entered into a domestic violence database, you become ineligible for concealed weapons ownership, firearms possession.
Ammunition. Can't have ammo.
So, these are things that people should know, because this doesn't even require an arrest, right? So, if Sheila gets a injunction against stalking violence or dating violence against me, my Second Amendment is done. I'm out.
And it wouldn't be shocking.
And by the way, the only exception is if you're an officer, and I actually represented an officer. I won. It was a bullshit case, but he couldn't have his service weapon with him outside of working. So he'd have to go.
Basically was reassigned to desk duty.
Well, no, he was still on the streets, but he'd have to check it in and check it out every day.
So he was allowed to carry when he was on the job, but only on the job.
Only on the job. And so
I'm surprised he actually was able to keep his job, depending on the allegations. But it's usually enough to pull the officer off the street. Just again, as we were talking about prosecutors and judges doing the CYA, why would the department do anything different? What if they have a rogue cop?
But this was one of those situations where it really was bullshit. It was like his girlfriend had an ex-husband who was an absolute maniac lunatic. He didn't know that his wife had ex-wife had a new boyfriend. When he found out, he lost his mind and then alleged that my client was like beating his kids, and that just wasn't really happening. It just was insane. So that he had filed on behalf of his children. It was trash. The case was trash.
How old were the kids?
They were teenagers.
So they were old enough to refute everything.
Yes. It was trash. Yeah. But anyway, for the pendency of it, this poor guy had to check his weapon in and out every day.
So that brings up another pro tip that I want to throw out for the folks. Why would you hire Sheila or Ed or me or any other lawyer as opposed to going pro se? Because we can get the job done correct. And nothing we say can be used against you. What you say can be used against you. What we say as your advocates doesn't go against you.
And I want to add one other thing, Mike. We've talked about this many times, and I can't believe I've actually forgot to add this. Mike, what happens if a cop comes to see me and says, let's say domestic violence. You're accused, the neighbors say that you beat the crap out of your wife. And I say to him, look, not only did I not beat the crap out of her, I wasn't even home when they're saying that I beat the crap out of her. I was in California. And then now we go to, and the officer wrote all that down on the A form. And now we're standing in a trial posture, and you want to say, because you're representing me, Your Honor, I want to introduce the statement that Mr. Martinez made where he had presented an alibi. What are they going to argue? Self-serving hearsay. So it doesn't even help to try to explain yourself because the prosecutor won't let a jury freaking hear it. They argue self-serving hearsay. So now that doesn't even come in.
Hang on, because you ran off a little bit to the left, and I wasn't specific, so I don't blame you for doing that. But I meant specifically in a civil domestic case. So if you want to get a restraining order against somebody, but much more importantly, if you want to defend against a restraining order, please, for the love of God, hire a lawyer. Do not do this by yourself, because if you lose, and without getting into any details, Ed's got a client right now that we're collaborating on a case together where the client self-represented in a civil case, lost the restraining order, then filed a pro se appeal, which obviously was going nowhere, and in the interim picked up a criminal case for violating the injunction. So, all of these things happen and they snowball if you don't have somebody who understands the rules, the regulations, the protocols, and can give you really good practical advice as to how to avoid the very reasonably foreseeable pitfalls and traps that are set for you.
I'm smiling because I'm thinking of, remember I brought up how sometimes you win cases that you thought you were going to lose and you lose cases that you thought you were going to win. I had an absolute loser of a case where, my guy had made threats in writing to kill this girl. It was terrible. He made up a website that was disparaging her. She was an attorney and he was making allegations about how she steals money from her clients and things like this, really hurting her reputation. Threats to kill her, lots of them. And if he hadn't hired someone, he would have 100% lost because she knows the rules of evidence. He doesn't, right? But she didn't know them very well because she couldn't introduce the text messages. She presented redacted ones that just were very misleading. She lost all credibility. And then I also had things that text messages from her that said that where she was also saying, I'll kill you and things like that. And I was like, this is just how they talk to each other, Judge.
Mutual
this is just
combat.
How they speak. Sometimes words are just words. There's no overt action here. That's not credible, whatever. So but he would have lost. He would have 100% lost if he tried to represent himself in the case.
So the takeaway from that obviously is, again, the same way that you should not enter an operating room without a surgeon, you really shouldn't be entering a courtroom without a lawyer. Look, if you want to represent yourself on your traffic ticket, the worst case scenario is a couple points and a hike in your premium, right? But in a domestic violence case, in a civil restraining order, whether it's, and there's many different types, we didn't really talk about it, but whether it's a DV, repeat violence, stalking violence, sexual violence, dating violence, any of them, you're going to be severely outgunned. And I don't care how smart you are. This is not an issue of intelligence. It's an issue of experience and knowledge and training. Either you know the rules of evidence, you know the rules of procedure, you understand the art of cross-examination and persuasive argument, or you don't. Right. You don't hire and this is not to disparage lawyers that write wills and trusts and do real estate closings all day. They perform a very vital function and they're very good at what they do and they know how to dot every I and cross every T. but I would hope that they also know their own limitations and that they wouldn't go litigate a case in a criminal or a civil courtroom when they've never done so.
What's that saying? A lawyer who defends himself has a fool for a client.
You know, I just did a PSA on that, by the way, proving that it was not Abraham Lincoln who came up with that quote.
Oh, did he?
Historian buff.
But it is true.
Yeah.
It's the same thing. If you represent yourself in a restraining order hearing, you're acting as your own attorney. You can't see the big picture. You're not objective. Even if you were to do a crash course in law.
Just as a funny aside, it reminds me of, and you may be a little too young for this, Sheila. So forgive me if I'm overdating you, but Ed will no doubt remember. It reminds me of the scene.
Watch
it reminds me of the scene from Bananas with Woody Allen, where he plays Fielding Mellish, and he has to he has to examine himself. He serves as his own lawyer, and he does his own cross-examination of himself. So 1 minute he's in the witness stand, and then he jumps out of the witness stand, and he cross-examines the empty chair, and then he jumps back in the stand, and he answers the question, and he goes back. It's just insane. You can't do it. You got to wear one hat, okay? Mm-hmm. And so. The point, if you guys are going to get any takeaways here, I would hope that the biggies are, number one, look, don't commit an act of domestic violence, all right? There's always another answer, the best being walk away, all right? If the relationship is good, if the foundation is solid, a little bit of distance, a little bit of time, everything will work itself out. You go back to par and you reset. What you cannot do is take back the punch, the slap, or the injury. So walk away. That's number one. Number two, if you do get involved in a case of domestic violence, shut up. Do not self-advocate. Invoke your rights. Let your lawyer decide when and where and how a statement should be made. Number three, if you get served with a restraining order, or if you want to take out a restraining order, consider going to a lawyer. If you want the restraining order, a lawyer's going to understand the buzzwords and the language that need to go in there to make a prima facie case and get you that temporary injunction. And if you're defending against it, a lawyer's going to be able to help you to figure out how to pick it apart, where the weaknesses are, and how to effectively cross-examine and deflate the allegations from your accuser. So I would say those are probably the three biggies. I don't know if you guys have any other pro tips you would throw in there.
One thing I will say, if you're in doubt and you don't know if you have enough for a restraining order, but you feel like you're in fear of your safety, file it anyway, because I find that a lot of times just filing it, a person getting served by a sheriff's deputy, some papers, it's going to be enough to get what you're looking for, which is for this person to buzz off and leave you alone.
But that's if that's what you want, because you also have to remember the corollary to that. Although, again, in the civil context, it's a little different. Because in civil, if I take out a restraining order against anybody, I have unfettered authority, and the court has no right to deny me the authority to withdraw it. Right. I can always file a notice of voluntary dismissal and say, this is my case, I'm done with it, and I'm divesting the court of jurisdiction. But that does not apply in criminal. In criminal, you are at the mercy of the state attorney's office.
Totally. I'm talking about a civil restraining order only, not criminal.
I just want to add two things in criminal. One, and you're right, Mike. I was talking more in criminal, but it's something that we need to bring up, and we tell people lawyer up, 2 times up, or however you say it.
Up X2. Hashtag up X2. Get it straight, Martinez.
You really should trademark it.
Shut up and lawyer up.
And the reason is because even if you think you're going to say something favorable for you, the state attorney will keep it out. It's called self-serving hearsay. Nobody will ever hear it. So just shut the fuck up.
Talk.
Number two, just shut the fuck up. Nothing. You cannot say shit to a cop that's going to help you. Trust me. Number two, if you like Sheila said, if you fear even the slightest bit of fear, file an injunction, call the cops, do what you got to do. Absolutely, do not hesitate. However, if you're just pissed because you caught them cheating on you, or you think they were cheating on you, or you're in the middle of a divorce and all of a sudden your spouse is with somebody new, be very careful what you do, because once that bell is rung, it cannot be unrung. It just can't. It's even if it gets dismissed criminally. I'm talking criminally, right, Mike? You're smiling because you know I'm right. This is a fucking major problem for the two of you for the rest of your lives as a relationship. So unless you're 100% sure that you're done and you're scared, don't use the fucking cops. just to retaliate. Don't use this because of a divorce and you want to get more more time sharing so you can get more child support. These are the wrong reasons to do this, and I'm telling you, it'll hurt you as well when you do this. Be very careful when you involve law enforcement into your life. That's my pro tip.
With that all said, let me thank Sheila for not only coming on our show and giving us great, intelligent, insightful data, but also for prettying this picture up beyond belief. Because I look at Martinez, he looks at me, and the audience is just happy as hell to have you. Thank you so much, especially on Valentine's Day. It makes it even that much more special.
My pleasure.
You're just an angel for giving us.
Enough. I'm getting a little. I'm about to puke in my mouth. Okay.
You're throw up.
You can flirt on your own time, Michael Haber.
I would say this to any guest. We appreciate you. We thank you, and we're grateful that you came on. Folks, I hope you got some good information from this show. We all wish you all a happy, wonderful, joyous Valentine's Day. Don't screw up the name on the gift. Make sure you get it right. And I guess we'll see you.
Can I throw one last thing? 30 seconds. I've seen this thing going around on Instagram and Facebook, pranking your spouse 5 minutes after they leave the house. Now this is the ongoing prank. You ever seen this shit? When your spouse leaves the house, you text them, "Hey baby, she just left. Come over now."
Oh yeah, that's smart.
Terrible idea.
I don't know what is the dumbest fucking prank I've ever heard, but this has to be top 2. Like,
you
are you
can't
out of your
even
fucking
talk
mind?
yourself out of that one, because what would you say if you accidentally did that? Oh, babe, it was a joke. It was a joke.
Like, that is the stupid. Guys, please, if you're even thinking of doing that today, don't ever do it. Don't do it on Valentine's.
I just stick with flowers, chocolate, dinner, drinks.
If
nice stuff.
If you're gonna
massage.
If you're gonna play that prank, here's a pro tip. If you're gonna play that prank, put about 15 G's aside for the lawyer. Okay, the lawyer you're gonna have to hire.
Minimum.
All right, guys, let me wrap it up by again thanking everybody for coming, for your time, your expertise. Audience, thank you for your attention. I hope that this was an enjoyable show. It certainly was for me. And we look forward to seeing you next week for episode number 31, when Ed and I can be back at your service.
Thanks
Sheila,
again, folks. Everybody.
Thank you, Sheila.
Thanks, guys. Thank you.
Happy Valentine's.
You too.